James Kaufman, World News Report today, August 10th, 2024. God bless you and yours, no matter where you are in the world. Please subscribe, give us a thumbs up, ring that bell for critical future updates. Maryland court allows state to disarm citizens. The Fourth Circuit Court upholds Maryland's so-called assault weapons ban, allowing the state to disarm law-abiding citizens. The United States Court of Appeals for the Fourth Circuit has once again turned its back on the Constitution, upholding Maryland's Oppressive Firearms Safety Act of 2013. This ruling, handed down by a majority of liberal judges, essentially strips law-abiding citizens of their God-given right to self-defense by banning a wide range of so-called assault weapons, including the highly popular AR-15 rifle, which is definitely not an assault weapon, it's a semi-automatic weapon. Mike Davis of the Article 3 Project expressed his outrage, stating, quote, 9 Democrat judges, along with an older, weak Republican judge on the Fourth Circuit, are allowing Maryland to disarm citizens. 5 Republican judges, including all 3 Trump appointees, wrote powerful dissents. The Supreme Court must step in and fix this, end quote. The ruling, authored by Judge Wilkinson and joined by several of his far-left colleagues, claimed that the military-style weapons like the AK-47, the AR-15, along with the Barrett 50 caliber sniper rifle, are designed for sustained combat operations and ill-suited for self-defense. The court further asserted that these firearms fall outside the ambit of the protection offered by the Second Amendment because they are allegedly more dangerous than other types of weapons typically used for self-defense. The court's decision is out of step with the Supreme Court and their more recent ruling in the New York and Rifle Pistol Association versus Bruin, which struck down New York's restrictive gun control laws. Now, the Second Amendment was never about self-defense. It was about, well, protection from the government and the government's overreach, which is exactly what's happening here. In Bruin, the court made it clear that the Second Amendment protects the right to carry firearms in public for self-defense without requiring citizens to demonstrate a special need. By contrast, the Fourth Circuit ruling upholds a law that severely restricts the types of firearms citizens can own, further eroding the right to self-defense. Again, the Second Amendment has nothing to do with self-defense, period. In his dissent, Judge Richardson, joined by Judge Niemeyer, Agee, Quattlebaum, and Rushing, rightly criticized the majority for its flawed reasoning and its departure from the Constitution's original intent. Richardson pointed out that the decision ignores a historical understanding of the Second Amendment, which was designed to ensure that citizens could defend themselves not just against criminals, but against a tyrannical government. Richardson wrote in his dissent, quote, the majority decides that Maryland's ban is perfectly consistent with the Second Amendment, but the majority's rationale disregards the Second Amendment and controlling precedent. Rather than considering the amendment's plain text, the majority sidesteps it altogether and coerces a threshold inquiry, divorced from the rights of historic scope. To make matters worse, it then misconstrues the nature of the banned weapons to demean their lawful functions and exaggerate their unlawful uses. Finally, to top it all off, the majority cherry-picks various regulations from the historical record and pigeonholes them into its preferred yet implausible reading of our nation's historic tradition of firearms regulations. God bless you and yours, folks. Let's hope the Supreme Court steps in quickly on this as they go house to house collecting firearms from individuals that lawfully own them. Please share, subscribe, and always remember that anything's possible in Bizarro World.